Good morning. It's a beautiful Saturday morning. I'm up late, out late, got a horrible headache. Everything was all weird yesterday. They gave us a apartment to use. It's just an unfurnished, empty apartment, and everything was going weird. My wife ended up moving the coffee over to the apartment, and along with like other stuff, because I don't know, my wife loves to nest, so she has the idea that if we're going to be there for like a week or so, oh god, who knows how long it's going to be, but her idea is basically that she wants to nest and have all the comforts of home, if you could count camping chairs and inflatable mattresses as comforts of home. Luckily, my wife and I both love to camp, so we have quite the extensive camping gear collection. So I guess maybe I should have spent more on the AC collection and less on the camping gear collection. Hindsight 2020, all that fun stuff. So I think what I'm experiencing now is an incredible lack of caffeine built up from yesterday. Or at least that's what I'm going to tell myself. Anyway, looking at some comments this morning, somebody said that they used to work for a media company and they were denied access to a couple murder trials, and they sued and they won, so they got access to the murder trials. And another person said that asked how the First Amendment can conflict with the Fifth Amendment. And another person asked like how rights in general can conflict. Well, so as far as like the First and the Fifth Amendment is concerned, there's two cases that you want to look at. Well, broadly speaking, to cover what's happening in the U.S. generally, there's two cases you want to look at. The first one is Estes v. Texas. Estes v. Texas, guy was on trial for something, I don't remember, it's not important, in Texas. They televised the hell out of it. They turned it into a media circus, and at the end of the day, the court thought that violated his Fifth Amendment right to due process. Oh no, you don't want the stick. You don't want the stick. He wants the stick. Oh, it broke, thank God. Nothing's more fun than getting whacked in the back of your legs by a stick from your dog, who's happily playing with it and doesn't know that he's just engaging in general douchebaggery. He's so damn cute though. I think if auditors were cuter, like if auditors cleaned up and went out looking nice and respectable. There's a mean puppy over there, or at least an excited one. So excited about the mean puppy? Yeah. Anyway, I think if auditors look better like that one, those two guys who were making a ruckus over the gal who got thrown through the doors, boy, they looked like rough fellows, didn't they? Oh, you can't judge people based on what they look like. Yes, you can. Everyone does it. You do it. You may not think you do it, but you do it. Everybody does it. That's what humans do. So, enjoy. So anyway, Estes v. Texas. So the Supreme Court said that no, you can't televise criminal trials. You just can't do it. And for justice, generally, you shouldn't. I don't remember if they said you couldn't do it on civil trials, but definitely criminal trials, nope. Well, they kind of walked that back a little bit in Chandler. I think it's Chandler v. Florida. In Chandler v. Florida, the Florida Supreme Court, the Supreme Court of Florida, so it is a state Supreme Court, had adopted rules allowing the televising, the broadcasting, there you go, and radio broadcasting and television broadcasting of trials, provided, certain conditions were met. And among those conditions were that, it didn't interfere with justice. And in that case, the guy was convicted or something, and he said, oh, this violates Estes v. Texas, and so it violated my rights, and I should get a do-over. And the Supreme Court said no. The Florida Supreme Court laid out rules that adequately protected your due process rights and the administration of justice. And what Florida had done is what you'll see basically in every state that I've looked at that has filming rules. Like even in the Ninth Circuit Court of Appeals, where the young man was denied entrance with a camera. In a courtroom, not in the courthouse, in a courtroom, if the judge allows it, you can have like a TV camera set up. And if 2 or more TV crews want to operate, they basically have to share that feed. So one station will broadcast it and the other ones get to share it. It's a joint effort. And if you want to do any audio pickups, have to go through the existing microphones and the audio system in the courtroom. And if you want to have a still photographer, you could have one still photographer who has to remain stationary. These are pretty common, pretty broad rules. You see them all over the place. And the purpose of that is to prevent the trial from turning into a media circus. Now you'll see those in states. Currently, as it has always been, you cannot film criminal trials in federal court. They just don't allow it. You can film civil trials if the court allows it, but you can't film federal trials. And you can't film outside the courtroom. You can't film in the courthouse in federal courts. And again, state courts are going to be different because their rules are propagated by their state Supreme Courts, and they have to deal with their state constitutions and state statutes. So there will be some variation among states. But at the end of the day, the whole point of it is to protect people's rights to a fair trial, to due process. And so filming in court, how could that possibly go wrong? Aside from the distraction factor of having a bunch of people waving around cell phones in the air trying to get the best shot. There could be witness intimidation. There could be jury intimidation. If you're allowed to film the jury, then you may, have one of the wise guys in your local mafia go and break one of the jurors' family's kneecaps and say, you better find my client not guilty. So there's the media circus, there's the potential for witness or jury intimidation. There is also the potential to have information that is not intended to be public leaked out. Like if the lawyers go up and talk to the judge, a sidebar or a bench conference, or however your local vernacular likes to call it. But if they're having a off-the-record conference with the judge, they may be talking about things that are incriminating to the defendant, but have been suppressed from the Fourth Amendment unlawful search or an unlawful seizure. And if that gets out, and there is a, mistrial or something like that, then that could taint further jury pools by having that information out there. And so beyond all that kind of stuff, if I am wanting to know how to win a case. What I want to do is I want to figure out what my opponent least wants me to do. Whatever he least wants me to do is the thing I want to do. And how do I find out what he least wants me to do? Well, gosh golly, I just have a friend with a cell phone, sit behind opposing counsel and record everything he does. Record his paperwork. It's free speech, you know. It's, if he doesn't want me to see it, he should more effectively conceal it. Record the conversations he has with his client. Well, free speech. There's no expectation of privacy in public. Free speech. If you didn't want me to capture it on my audio recording device, you should have been more careful. You should have learned sign language. So it has a general chilling effect in the courtroom, and that's why the courts place restrictions on it. And then outside of the courtroom, again, clients talk to their attorneys and attorneys talk to their clients outside of courtrooms. And you can kind of gauge when people are going to be able to overhear you. It's a lot harder to gauge when an electronic device is going to overhear you. Electronic devices can be much more sensitive than human ears. So those are some of the ways in which the Fifth Amendment and the First Amendment can come into conflict. And outside of the courtroom, the balancing test might be a little bit different, but inside of the courtroom, being in court is all about the Fifth Amendment. It's all about the fair administration of justice. It's all about due process. That is why you're in a court. And so the Fifth Amendment should have supremacy over the First Amendment in a court. Now, there's other ways in which the First Amendment and the Fifth Amendment come into conflict. I don't remember the case off the top of my head, but there was after Pruneyard in California, there was a federal case. It was based off of a Oregon issue, because Oregon, like California, allows a lot of free speech activities in their shopping malls. And where the Fifth Amendment pushed back on the First Amendment is in the takings clause of the Fifth Amendment. You can't take anything from somebody else without due process. It's a violation of due process. And the state was essentially taking from the mall owners the right to control what happens on their property, the right to control who gets to speak and what they get to speak about. And so the Supreme Court narrowed down what you could take from these property owners without due process, without either compensating them for what you're taking or having some sort of hearing, etc. So you can't just say that every person ever gets to say and do whatever they want in a shopping mall, because you're violating the due process rights of the shopping mall owner. There are the other classic instance of where rights abut is in abortion. And I hate to bring it up. I know some people feel really uncomfortable talking about it. I'm not advocating for any particular side on it. I am just expressing how rights can abut. In abortion, the mothers, they've determined it was a Fourth Amendment right. It was based on the right to privacy that allowed the mother to get an abortion at certain times, you know, before the child's viable or whatever. That had to be contrasted. Now they contrasted it with the state's right to protect the lives of its citizens, of the lives of the people in it, and the baby's life, child's life, the fetus's life, what have you. You're not going to get it. Just relax. squirrel's gone. So in that instance, you can clearly see you can see the mother's substantive right to privacy abutting the fetuses, the babies, the child's, whatever, what have you, right to life. Because there is a substantive right to life. A substantive due process right to life. I think there's also a procedural due process right to life. I'd have to double check on that. I know it's procedural. They can't take your life without due process, and that's procedural. But I think there's also a substantive due process right to life. Thank you for wrapping me up so effectively. I appreciate it. So yeah, rights can and do push against each other. Everybody wants to forget the 10th Amendment. Says that any rights not specifically enumerated are left to the states and the people. And that is a right. And, well, those are rights, I should say. It's a package of rights. And those have often come into conflict with other rights. The state's right to trespass people from state property, non-traditional or non-public forums, I should say. That right has often abutted an individual's right to First Amendment. There was some talk, I don't remember where it was. Maybe it was on Discord about hats and masks and things like that, and making them part of a religious symbol. And that's a First Amendment issue right there. So, First Amendment is a big thing, and the state can control you wearing a mask. That's just patently obvious. They can control it. They do it. There's lots of states who have statutes in place specifically about wearing masks in public, and they did it to fight the primarily in the South, to fight the KKK, because you know those guys like to roll around in masks. So they have a lot of anti-mask laws in the South, and they carve out exceptions for like Halloween for kids under 16. Halloween, wearing a gas mask if there's a gas attack or a civil warning or something like that. So they carve out exceptions that seem reasonable. But I have not yet seen a successful First Amendment freedom of religion challenge to wearing a mask in those states. So, again, it's a conduct kind of thing. I forget if it's the lemon test. And lemon stands for something, and I forget what it stands for. But essentially, like, you're looking to see if it's the least kind of restrictive thing with the fewest government entanglements. No, it's not the lemon test, because... it's the peyote test. The state of Oregon had laws against peyote, and some Indian tribe wanted to use peyote. I forget what the name of the case was, but they wanted to use peyote, and the Supreme Court held that the laws of Oregon regarding peyote and drug use they weren't targeting a religion, and it was kind of like the conduct based restriction on the First Amendment, freedom of speech. I don't remember the exact analysis, but it was contrasted to another case in Florida, I think it was Florida, where voodoo practitioners were killing chickens and stuff. And I guess it was pretty nasty. And so the town or the state, I think it was the town, passed laws about how you can kill animals. And that one wasn't constitutional because they did it for the purpose of restricting the practice of the religion of these voodoo practitioners. So from my vague, I don't play around in the Establishment Clause, so you'll have to forgive my reaching back to bar exam kind of stuff and vaguely remembering it, but that's the general gist of religion. And also the government can't like determine if your religion is like a real religion, but they kind of also can. It's a little weird. The like they can't figure out whether you really believe it. They have to assume that you really believe it. But there are tests that they can use to determine whether or not they are going to recognize the religion and the religious practice. And I don't remember those off the top of my head. And quite honestly, my head hurts right now. So I'm going to call this one. I appreciate you sticking around for it. And I don't know if I'm going to make any videos today unless my head starts feeling better. Thanks for watching. Have a good day.